Good evening, everyone, and welcome to the Thursday evening seminar with Fletcher Day. Tonight we are joined by Jon Sharp, all the way from Scotland, and he is going to be looking first in a new series with Jon, looking at construction and insurance case law. He's going to be doing a roundup of recent case law and how this will impact sectors and therefore possibly or potentially your projects. Without any further ado, I will hand over to Jon. As always, if there's any questions you'd like to ask, please feel free to use the Q&A or the chat facility in the bottom toolbar, and he will happily answer any questions at the end. Jon, over to you.
Thank you very much indeed, Julie. Good evening, ladies and gentlemen. Good evening, all. Yes, right, construction insurance case law roundup. I'll deal with insurance briefly to some extent at the end, if that's okay with everyone. It isn't so much a law roundup, it's just concerns and issues that have arisen recently. Yes, of course, there's a couple of cases in there, so no need to worry about that. But I appreciate at the moment that in the construction industry, there are a number of issues. Julie and I, last November, Julie said, do you want to give a Brexit update? And in that, I said, there's going to be some problems. I didn't anticipate, obviously, the fuel situation, but I did anticipate an increase in the cost of construction products, in particular timber. I did anticipate the cost of construction products going up because of the effectively border charges that we now have from Europe. So I appreciate there's lots of issues at the moment, and I don't wish to add during this seminar to everyone's woes, but unfortunately there may be a few more on the way. That's me. Details are on the... Have a look at them if you'd like to. And let's start first of all with competition. It's an area that I think sometimes people forget about, but it's nevertheless there. So we've got the Competition and Markets Authority, as I'm sure you all know about. But there is going to be increased scrutiny on this sector due to higher government investment in construction projects at the moment. The CMA have fined 67 million in the last couple of years, and they've disqualified 11 directors and brought 2 criminal convictions. That's only in the last couple of years. Now, what do the CMA do, and why do they want their role to look as effective as it can be? Well, they want competition to work effectively. They want building companies, construction companies, it doesn't matter of what size, to be competing and giving the most competitive quotes to any client, but in particular, the government. As the government is now the biggest construction sector client, with 1/4 of all construction output government funded, then they are really on the ball at the moment. So it's a word of warning. They haven't gone away. They are there. And in particular, they are looking out to make sure that there's no illegal or collusive conduct. And as I said, it doesn't matter whether you are a large construction company or a small construction company, or a small building operator that wants to, that specializes in one particular sector. That is not, they don't care. CMA want to see fair competition between everyone so that the employer gets the best possible price. So just some examples, and it doesn't matter which area, as I said, groundworks products, The last 2 years, illegal sharing of pricing information and collusion on prices and strategic activity over 6 years led to a 15 million fine. Roofing materials, rolled lead in this particular case, but it could be any sort of roofing material. There was a £9 million fine for price collusion and exchanging commercially sensitive information. In the concrete drainage business, there was a £36 million fine for price fixing. Office and fit out services, who would have thought it? 5 companies were fined for bid rigging. Galvanized steel tanks, price fixing and bid rigging led to a £2.6 million fine. Directors of companies as well will also be investigated to see whether or not they had direct knowledge of the practices that have been fined. And if they are, they will go to prison. Be under no illusion that they can break, if you like, the corporate veil, and they will look at what directors knew about what was going on within the company. Now, there's likely to be an increased vigilance level because of the increased government investment in the construction sector. So now is really the time to review your internal competition and compliance processes. Make sure that when you are submitting bids, etc., for construction projects, that these are genuinely your own bids, that you haven't been, I suppose the expression might be, tipped the wink by somebody else, because that's illegal. And if you get caught doing it, excuse me, then the penalties are severe. Next, a nice case, triple point against PTT Public Company. I'll just summarize the facts for you. It isn't actually a construction case, but the courts, not only at first instance, but at Court of Appeal level and at Supreme Court level, all made reference to construction contracts. And therefore, it has to be assumed that these principles will from now on apply to construction contracts. By a contract, PPT Public Limited Company engaged Triple Point Technology Incorporated to provide a software system. The work was to be carried out in 2 phases, and payment for the work was to be made by specified milestone dates. Certainly in construction contracts, there are very often milestone dates. Triple Point achieved completion of stages 1 and 2 of phase 1, 149 days late, and PTT paid them for that work. Triple Point requested payment of further invoices in respect of work not yet completed, which PPT refused to pay. Triple Point suspended work and PTT terminated the contract, maintaining that Triple Point had wrongfully suspended work. Triple Point commenced proceedings against PTT, claiming sums due under its unpaid invoices. PTT counterclaimed for liquidated damages for delay prior to termination and for the cost of having to procure a replacement system from a new contract. Now, this went to the Court of Appeal, and the Court of Appeal were not particularly sympathetic to any of these arguments, and so the appeal went to the Supreme Court. The Supreme Court held that PTT were entitled to liquidated damages up to the date the contract was terminated, and general damages after that. PTT's appeal on that issue was unanimously allowed by the Supreme Court. There was another argument in relation to negligence, and limitation of liability in respect of negligence applied to both tortious act and breach of contractual duty of fill and care. Therefore, damages for the breach were not capped by PTT's appeal on this issue, which was allowed by the majority. It was clause 12.3 that was of particular importance in the contract. This case is widely reported now, so I won't bore you with too much more of the detail, but it's certainly worth a read. However, it is worthwhile noting that the Supreme Court didn't stretched, I think is the probably right word, the existing law, and gave a common sense and practical decision on this. And this is not the first time they've done it. They gave a common sense and practical judgment in relation to most of the business interruption claims. And there's another couple of examples in areas which are way away from construction and contract generally, where the Supreme Court is increasingly looking at commercial reality when handing down its judgments. Now, at the present time, these judgments are likely to increase. I'm not going to pass any comment on that whatsoever, other than to say very often, certainly House of Lords decisions before it became the Supreme Court were often criticised for lacking no commercial reality at all. That's not how it works in real life. So increasingly, the courts are, to some extent, stretching the law a little bit to make sure that the law now actually reflects what commercial reality is. As I say in the slide, these are likely to increase. There is a reference to the case below. As I said, it's widely reported and there's lots of commentary, but it is an important case, even though, bizarrely, it had very little to do with the construction industry. It was a software contract. But all courts at all levels made reference to construction contracts. So it's given some clarity in that area of law. It's an important case, and those of you that advise or are in a position to advise construction clients, then you should always have a look at this case. It is quite important. Next, the Building Safety Bill. Now, this, I think, has been reported again in the press, but it's worth bringing it to everyone's attention. Now, it's still under, I think, final draft, but it's proposed that the time limits in respect of bringing an action under the Defective Premises Act 1972 and the Building Safety Bill, sorry, Building Safety Act 1984 are going to be extended. The proposal is to extend the time to either 25 or 30 years. That's a long, long time. I'm not quite sure how the insurance industry are going to react to that development. But nevertheless, I'm sure all it will do is just increase premiums yet again. There will also be new implied terms in residential building and residential renovation contracts. These will be, as far as I can understand it, automatically applied, whether or not they're in the contract or not. And these terms are quite draconian. If you'll bear with me, I will read these to you so that you're aware. In fact, I'll just read the first two because it will give you a flavour of what's coming. Every residential building contract is to be taken to contain terms that the residential unit is fit for the purpose of ordinary residential occupation and is likely to remain so for a reasonable period if kept in appropriate repair. The residential unit in question is constructed in all material aspects as described or stated on the approved plans. The residential unit is not subject to any building safety risk. The materials incorporated in the residential unit are as described in any approved plans. The materials incorporated in the residential unit are of satisfactory quality. The design of the residential unit is of a reasonable standard. The design of the residential unit is prepared with reasonable care and skill. All works in connection with the construction of the residential unit are executed with reasonable care and skill. And the residential unit complies with all material aspects, with all applicable statutory requirements and with all applicable building regulations in force as at the date of completion. It goes on. Every residential renovation contract is to be taken to contain terms that any renovation works do not render the unit unfit for the purpose of ordinary residential occupation, do not create any building safety risk, do not involve the incorporation of materials in the residential unit which are not as described in any of the approved plans, do not involve the incorporation of materials in the residential unit which are not of satisfactory quality, are executed with reasonable care and skill, and do not render the residential unit materially non-compliant with any applicable statutory requirement or with any applicable requirement of building regulations as at the date of completion of the renovation works. Now, it's not yet certain that these proposed amendments will make their way through into the Act, but the concerns that have been expressed in relation to the extension of the time limits to 15 to 25 years will be exacerbated by the additional time periods proposed here, including practicalities around document retention, available reliable witness evidence, and solvency and continued existence of the party. Now, again, I'm not sure how the insurance industry are going to react to these proposed amendments. I suspect their view will be, well, hang on a minute, that's giving us an unended potential liability, especially given the Third-Party Rights Against Insurers Act, which says that you can stand in the shoes of an insolvent company if potentially there was a claim against that insolvent company. So it's a question, I think, this time of watching this space to see whether or not, to see what is actually enacted by the Building Safety Bill. Payment notices and pay less notices. Been a recent case on this. I'll just run through the facts with you, if I may, very, very briefly. If I can find my notes. I do apologise, ladies and gentlemen. Downs appointed Lex Manbia, I'll call them L, just be easy, as to act as contractor in the construction of 4 blocks of flats in East London. The contract of the form of an amended 2011 JCT design and build contract. The due concerned L's February 2021 interim payment. The key facts are set out here. The due date was the 26th of February 2021. On February 2021, L submitted an interim application. The sum stated due was 1.8 million. On the 3rd of March 2021, the employer's agent issued a payment notice stating that 97p was actually due. The employer's agent explained in its covering email that it had taken longer than anticipated to assess L's application because it was sent on the due date, and the volume and the form of information provided made it difficult to complete the valuation in a timely manner. Accordingly, it was said that a further payment notice will be issued to you in due course and will not affect your payment date. On the 9th of March 2021, the employer's agent issued the second payment notice to L, in that the amount due for payment was 657,000, which was subsequently paid on 26th of March 2021. L commenced an adjudication in relation to the February interim payment, and the matter ultimately came before the TCC for an enforcement hearing. One issue before the court was whether the initial payment notice on the 3rd of March had been validly given. Downs conceded that its second payment notice was out of time and therefore invalid. However, it argued that its first payment notice was valid as set out and as it set out an agenda for adjudication. This phrase was used previously in a case called Henia Investments against Beck, and it has been for many years the test of validity of a payment notice. Now, the court found the first payment notice was invalid. Excuse me. The second, even though it set out the basis on which the sums claimed have been calculated, apologies for the typo there, ladies and gentlemen, it showed no evidence that the party sending the payment notice believed it to be true. Both now appear to be needed. So you not only have got to set out the basis on which the sum claim has been calculated, etc., but you've also got to believe that that is what the true costs of the works are. Both seem to be required. And I would also assume, it wasn't specifically mentioned in the judgment, or not as far as I can see, that the same will apply to pay less notices as well. So this is a real change. Again, I've given you the case reference below. Please do have a read of the case. As we all know, payment notices and pay less notices are always important. And it's important that they are got right. And in the light of this case, in my view, increasingly so. Don't put in payment notices when you really don't think that those monies are due. That's not going to be acceptable anymore. You need to set out the basis of your calculations and believe them to be true. And both now seem to be required for a valid payment notice, and presumably pay less notice. Cladding, I'm very sorry to have to mention cladding, but it's still a real issue. There seems to be an increasing issue with regard to buildings between 10 and 18 metres. I think, as we all know, that buildings over 18 metres defective cladding, yeah, you're eligible to a grant, etc. But what about buildings between 10 and 18 metres? Those buildings may still present a fire safety risk and might be subject to the proposed loan scheme. The issue of cladding, I don't think, is going to go away anytime soon. And the CEO of the British Safety Council has said it's indefensible that the government has not protected all leaseholders of properties with unsafe cladding from paying for the cost of its removal when the fire safety problem was not of the leaseholders' making. I don't think you'll ever get to the stage where buildings over 10 metres which are clad are going to be subject to the loan, but buildings between 10 and 18 metres, if you've been refurbishing those, possibly there's no eligibility for some sort of loan or grant here. But in addition to that, there's going to be an increasing call for the effectively removal of cladding and refitting of proper cladding in relation to buildings between 10 and 18 metres high. As I said, the issue of cladding isn't going to go away, and this height of building is increasingly becoming a centre of concern. And don't forget the Health and Safety at Work Act. There seems to be, at the moment, from some clients that I've spoken to recently, that the EU introduced a number of health and safety things, but we're out of the EU now, so they don't apply to us anymore. That couldn't be farther from the truth. Much of the EU regulation that came in various different acts has not been withdrawn and is unlikely to be withdrawn for at least another 2 to 3 years, if it's withdrawn at all. So don't think that just because we've left the EU, that any of the EU imposed regulations have ended. They haven't. They're all still there. They haven't gone away. They've not been repealed. They're all still applicable. And health and safety still remains one of the main focuses of the government. Now, this case is actually quite a straightforward case. Yorkshire company just been fined 40,000 by the HSE under the Health and Safety at Work Act. 7 employees were diagnosed with HAVS, hand-arm vibration syndrome, also known as vibration white finger. It was only when the company brought in a new healthcare provider that the new healthcare provider diagnosed 7 employees with this. I don't suspect the company retained the services of the new healthcare provider for very much longer, but nevertheless, they diagnosed it. There was a breach of the Health and Safety at Work Act, and therefore the company was fined appropriately. So don't forget health and safety. Don't forget your EU obligations. They are still there. They have not gone away. You will have seen talk in the papers about all these EU regulations are going to be withdrawn. Yes, they may be in due course, but at the moment, they still apply, and in my view, are likely to apply for some considerable period of time. I said at the beginning I would touch on where we are in relation to insurance. I will do so now. Firstly, there is no sign whatsoever of any insurance premiums going down at the moment. In particular, in relation to professional indemnity. But all insurance premiums for construction work are going to go up. There's a number of reasons for it. There's been a couple of market-wide losses, 737 MAX, and a couple of others which have forced premiums up anyway. But this is the hardest market that I've known in 32 years. And it's likely to last for another 4 to 5 years. The other reason, of course, it's going up is because of the business interruption claims. Where are we with those? Well, there is still a fight going on, despite the Supreme Court's decision, which at first blush, at least, looked like a very favourable decision for policyholders. But the insurers are digging their heels in. They are not going to give up and start paying out sums of money quickly. They will want proof of your losses. They will want to make sure that their policy wording coincides with what actually happened at your premises. Remembering that the Supreme Court made a distinction between those businesses that were forced to close, so pubs, restaurants, nightclubs, and those businesses that actually could still continue. And the construction industry was part of that. It was allowed to continue, subject, of course, to the guidance given by the construction effectively regulator and by the health and safety executive, who said, unless basically you follow these guidelines, we will shut you down. And that's going to be an interesting little argument to have with insurers. Well, yeah, we weren't forced to close, but if we didn't close, we'd have been shut down anyway. I'm not quite sure what the outcome of that's going to be. There have been some cases as well recently where people have tried to extend the wording that they got. So there has been a case where someone tried to argue that plague, which was in their policy wording, was obviously COVID-19. I'm afraid the judge didn't have very much sympathy with that argument and described them as living in fantasy land. So it does very much depend on your circumstances. But as I've said before on numerous occasions, you do need to read your policy wording to see what your policy wording actually says. And it also needs you to remember that it's all very well being able to make a claim, but you've still got to prove that you've actually lost. Insurers will not pay out just because your business went into a bit of a downturn. That's not what business interruption is about. Business interruption is about some form of physical or potentially extended coverage in terms of diseases, which effectively stopped your business from operating and trading. The fact that there's been a global downturn and your business didn't do very well is not going to be something that insurers will pay out for. So to conclude, well, I hope that hasn't depressed everyone too much, but these are other issues that everyone still needs to remember and still remain focused on. Business interruption is still going to be difficult to claim because it will go to the question of quantum. Okay, yeah, the policy covers it, but what did you actually lose? Is your loss too remote from what actually happened to you? Were you forced to close? Did you have to? If you didn't have to, and this is the reason why most offices of lawyers, accountants, whatever, won't be able to claim on business interruption policy, is because the government didn't say you couldn't go to your office. Every employer said, please don't come to the office, stay at home, obey the government guidance. But there was nothing to stop me going into my office and sitting in my space and doing my work from my office. No one would have stopped me doing it. And that's the difference. And I think everyone needs to look at that and remember that. So, ladies and gentlemen, I hope that was a not too depressing roundup of where we are at the moment. But thank you very much indeed for your attention this evening. And hello, Julie, you're back.
I am indeed back in the room, John. I'm pleased to notice that you managed to fit the words policy wording. Read your policy
As
wording.
always, I would
into
not
a seminar. It wouldn't
I've
be
got
one
to
of
get
yours.
policy wording in.
Okay, now's the time if you have any questions for John to fire those into the Q&A or chat panel. Otherwise, it just remains for me to thank everyone for turning up this evening. We do have some seminars next week. We are with Mohammed Hack on Tuesday at 6 p.m. for a case in point live, where he's looking at a well-known construction law changing case and examining the decision, why that was made, how it was reached, and the impact on the sector. Wednesday, we're joined by John at 8 in the morning. Lucky John.
Sorry, what time, Julie?
8 in the morning, John. It's fine. Don't worry. For effective delay analysis, the tools and techniques. And on Thursday, we're back with Mo with the latest in his new series, Changes in Construction Contracts, the Valuation and Other Implications. That's at 6. Now, if anyone would like a place on any of these seminars, please drop us a line, seminars@fletcherday.co.uk, and we will book you in and send you the login details. Equally, if you'd like to be included on the distribution list for our monthly newsletter, telling you what's coming up, what's new, interesting articles, insights, etc., please drop me a line, seminars@fletcherday.co.uk, and just request to be popped onto that distribution list. Okay, well, it appears that you've covered everything, John. So thank you very much, all. Thank you, John, and we look forward to seeing you all again very soon.
Yes, Julie, if anyone does have any questions, they can, of course, email me privately at jon.sharp@fletcherday.co.uk, and I'll be happy to answer those.
Thank you very much, John, as always. Okay, thank you very much, everyone, and good night. Thank you, John. We will see you again.